fiduciaries. Now, just to explain what a data fiduciary is, a data fiduciary is someone who processes data. Now, it is a company like Facebook, it is an e-commerce company like Amazon, it is an online gaming platform. Any sort of platform that processes your data is a data fiduciary. And now the person who the data belongs to, that is people like you and me, who share data with data fiduciaries, are referred to as data principals. Now, one of the key sort of obligations that have been set forth by the Data Protection Act 2023 is that your data cannot be processed without your consent. So now if a data fiduciary, that is, if a company, now for the rest of this call, I'll sort of use the example of Facebook. Now, say if Facebook wants to get your data for you to sign up and create an account on Facebook, it can't do that without your consent anymore. It requires you to be given a notice. So when you sign up, Facebook will give you a notice saying that we need XYZ personal data from you, and it is going to be used for XYZ purposes. So this is a notice that is legally mandated for companies like Facebook to give to you. So now rule 3 of the data protection rules clarify how exactly this notice is to be given. This notice has to be in a clear and plain language, and it has to have the list, an itemized list of what data they will be taking from you and the purposes for taking this data. Now, the problem here is that we recognize that a notice given by data fiduciaries is of primary importance, but the rules haven't actually mentioned how exactly this notice is to be given. The nature of giving the notice, how exactly this notice will look, is largely left up to the companies. And we know how terms of service and conditions are right now given by these companies. We know that dark patterns have become a reality. So we do not have a lot of hope that the way that notice of consent is given will actually be in a way that people can understand, especially given that technological literacy is not very high in a country like India. So that is a major concern we have. These rules were quite vague and should have been more prescriptive about how to give notice by data fiduciaries. Another key point of Rule 3 is that there is an obligation on data fiduciaries to have a website, an app, a platform of any sort through which you can withdraw your consent. Not only do you have the right for your consent to be obtained before processing your data, you can withdraw this consent later. If you change your mind, you can withdraw it, manage that consent, and data fiduciaries have to tell you which app or platform you can use to do this. This is primarily on notice. Can we have the next slide? Rule 6 is on security safeguards. So now, as we know, after we give consent, companies like Facebook now hold our data with them. They have our personal data that we have consented to them holding. And now, to make sure that this data is safe, the government has implemented a reasonable security safeguards. Now, the problem with these security safeguards is that they are quite vague. They basically just say you need to make sure that this data is encrypted, masked, and make sure that you protect against unauthorized access. You make sure that in case of loss of data, you have a way to still obtain this. So there are vague security safeguards that have been given, but not enough specifics on the standard of safety. How exactly you implement these security safeguards haven't been given. So when you actually enforce these safeguards, IFF has a lot of doubt whether it'll actually be enforced in practice due to the vagueness of the way in which they have framed this. I'm sorry, could everyone please make sure they mute their mics? Okay, can we have the next slide? So the last sort of obligation on data fiduciary is an obligation on publishing contact information for data processing. So now under our Data Protection Act, companies are required to come up with something called a data protection officer. So now what Facebook would do is that they would set up a data protection officer, which is a point of contact to manage all of the obligations on behalf of the company from under these act and rules. So now you have grievance redressal mechanisms. How do you route that? All of these will be taken care of by your data protection officer. And the data fiduciary, these companies have to publish the contact information of data protection officers on their website so that people like me and you can easily reach out to them. Can I have the next slide? Okay, Now we will move on to consent managers. So this is a new sort of set of people or entities that have been conceptualized by the Data Protection Act. So if we talk about a consent manager, think of this in context of a stockbroker. Now, say you want to buy stocks, instead of directly going to the stock market, you route your request to buy stocks through a stockbroker, right? So this is exactly what a consent manager does. Like I mentioned before, now you have to give your consent to companies before they can process your data. Now, instead of you directly dealing with the companies and giving your consent directly, you can instead engage a consent manager. So you will give your consent to the consent manager, who will route your consent back to the company. So that is what a consent manager does. So the new rules now specify the sort of conditions that you need to be a consent manager. For instance, you have to be an entity incorporated within India. And it also gives the obligations of the consent manager. That is, consent managers have to maintain a platform or a website that data principals, people like you and me, can use to manage our consent with various data fiduciaries, right? And this one has to be interoperable, this platform, i.e., it has to be something that can work across multiple applications and can be easily accessible. Now, our concern with consent managers, apart from the business side of things, is that we, being in India, and again repeating, where technological literacy is quite low, and consent managers, probably the government's logic being something to remedy that. The problem is, how will people access consent managers? The accessibility for large swaths of India still remain to be seen. So their effectivity and accessibility is something that depends on implementation. Can we have the next slide? So now we will come to, sorry, could we go back? Exemptions from the Data Protection Act. Now you have two key exemptions that the government has carved out, wherein the provisions, all of the obligations that I just mentioned, will not apply. So the first exemption is data processing in furtherance of any sort of subsidy, benefit, or license that the state is giving. So now assume you sign up for Manrega and you use their app. Now, if you have previously, you are part of the Manrega scheme and you're already on their platform. Now, to process your data, the government does not need to take your consent, because you've already consented to this. And to make sure you continue to get the benefits of this scheme, you won't need to sign up again. And secondly, if the government already has your data through some sort of government register or any sort of database it maintains, it won't take your consent again, and it is exempt from this app. So now our primary problem with this is again on digital exclusion, right? So most logically, the idea of having this exemption for subsidies and digital services provided by the government is to actually expand delivery of services through digital means. But the problem is that even right now, we're facing a lot of issues when it comes to online delivery of services. Again, talking about Manrega, you're supposed to get, for getting benefits of Manrega, enter daily logs. Like if you're a worker, you have to log on and say, okay, I am present today. There is a role taking. But evidence has shown that this role taking is insanely inefficient and is not something that is working for Manrega beneficiaries. So without fixing digital exclusion, without fixing the gaps in online delivery of services, expanding this sort of exemption to online subsidies, benefits, is something that is most likely not going to work. The second exemption that we have from the Data Protection Act is an exemption for research and statistical purposes. So if you are data processing for research to create some sort of statistical analysis, you are exempt from the obligations under this act. Could we have the next slide? Okay, intimation of personal data breach. Now this is where data fiduciary companies, if say Facebook is holding our data we've consented to be given, and a breach occurs, some sort of security issue occurs, and our personal data has been breached. Now we are making sure there is an obligation on Facebook to inform, firstly, users, that is the people who the data belongs to, you and me, and secondly, the Data Protection Board. I will come to details on the Data Protection Board later on, but it is basically an authority that the government has set up to take care of issues like personal breach is a new regulatory authority that they've set up. So what is required under this rule is that the moment a breach happens, within 72 hours, a company, so Facebook will prepare a sort of report where there will be like, okay, this is the time, date, location on which the breach occurred. This is the kind of data that was compromised, and this is how we're going to fix it. So within 72 hours, make this report and submit it to the data protection board. Secondly, they also have to inform the users that a breach occurred. But it is to be noted that no timeline has been given for companies to notify users. So they could take their own sweet time and not inform users in a speedy manner when any sort of breach takes place. And also here, I would like to point out that IFF has a website that it maintains. It's called Plug the Breach, where we track data breaches across the country and give you information about this. Anjane will just ping the link to Plug the Breach. You can go through this. Can we have the next slide, please? Okay, now we come on to Rule 8, retention and erasure of personal data. So any data protection regime is guided by privacy principles. So these are principles like data minimization, erasure, retention, things like that. Now, if here, particularly the privacy principle of erasure is enshrined, that is after you give your data to somebody to process, after it serves its purpose, after the data that is given has served its purpose, it needs to be erased. So now this is given in Rule 8, which says that data needs to be erased generally 3 years or the commencement of these rules. And before you erase such data, you have to tell the data principles, it will tell you and me that your data is being erased unless you have any sort of objections. And the exact nature of doing this erasure process is given in a schedule in the rules. So data fiduciaries, companies are split into different types. You have e-commerce data fiduciaries, gaming fiduciaries, and social media fiduciaries. So a timeline of for what kind of data and the erasure process has been given in the schedule. Can we have the next slide? Okay, now we will come to one of the more contentious parts of the rules, which is parental consent for children's data. So now the Act sort of recognizes and the rules further this understanding is that children being online as a sensitive, vulnerable group need to have some amount of protection to protect their privacy and their data in online spaces. And now the definition of child is anyone under the age of 18. So now if anyone under the age of 18 is, say, signing up for Facebook, before they create their account, the rules now require you need to get that child's parents' consent before the kid signs up for an account. Then how do you verify that the person who's giving the consent is the child's parent? So this will be done either through reliable IDs or DigiLocker. So we are assuming that this will most likely result in parents having to give their government ID to show that they are actually parents. This causes a lot of issues in terms of privacy because now what is happening here is that there is an increased amount of data being collected. And there is also a big chance of social media companies and government IDs being linked together. Not just social media companies, any sort of data fiduciaries and government IDs being linked. Another sort of glaring gap that exists in Rule 10 is how do you actually make sure someone is a child? How do you trigger the need for parental consent? So unless some kid comes forward and is like, hey, I'm a child, I will take my parents' consent before you can access my data, there is no way that there is no mechanism prescribed for the government or data fiduciaries to understand who is a child. So now our fear is that the government or data fiduciaries might come up with age verification, an internet-wide age verification where every single person on the internet would have to verify their age to determine who is a child and who is not a child. This again increases surveillance, links government IDs to private companies, and is completely against the privacy principle of data minimization. This is not really furthering privacy and the protection of children not necessarily protected because all you're doing is the government has just shifted the onus of making sure children are safe to the parents and being like, as long as parents have consented, we are in the clear. So there's a lot to be considered in this section. We'll hear more from Gautam and Vrinda. Another really contentious part, again, in this rule is that along with the consent for children, they've also required, if you are a person with disability, you need your guardian's consent for your data to be processed. And now this is very problematic because they have clubbed all persons of disabilities and require all of them to get their their guardian's consent. Now, this is an overbroad generalization where you're assuming that any person with disabilities does not have the mental capability to adequately consent for their data to be processed. And that is not necessarily the case. Ideally, there should have been a gradation, understanding of mental capabilities, both for children and for persons with disabilities, before they came up with guardian or parental consent. Can we move on to the next slide? Okay, significant data fiduciaries and their obligations. So significant data fiduciaries are a special class of data fiduciaries that the government has created, and how the government has given itself the power to determine which data fiduciaries will be significant data fiduciaries. And this is based on an assessment of things like volume, sensitivity, the impact of the data that they're processing. And it's a special class and you have higher obligations. For instance, data fiduciaries need to have a data protection officer, like I'd mentioned before, and this person needs to be located in India to make sure compliances happen smoothly. And they also need to have data protection impact assessment audits that have to be conducted on a yearly basis. There is also a requirement for data localization, which we will come to later. Can I have the next slide? Rights of data principals. Now, data principals, you and me, have rights that have been given to us under the Data Protection Act and the data protection rules. So primarily, I would say, if you have to broadly classify it, it's a right to disclosure, right? We have a right to know, to make sure that we have a channel available with data fiduciaries to make sure that we can submit our grievances. So this basically says that you have a right to make sure that you have adequate grievance redressal mechanisms. You have a right to make sure that information about data protection officers are given online, and that you always have a channel of communications ready. You have a website with procedures given on how exactly you can give your consent, how you can withdraw your consent, and making sure you know all of this is your right now under this act. Could we move on to the next slide? Okay, now we come to cross-border data transfer. That is, data is the new oil, is something that flows between countries. Now, when you sign up for an account on Facebook's data centers not being kept in India, so your data, whatever you enter, is sent and stored in Facebook's data centers in the US. So that is a cross-border transfer of data. And now the Data Protection Act has come up with a restriction on this transfer of data. So it's what we call a blacklist approach. So what this basically says that you can have cross-border data transfers except to those countries and territories where the government says to these places you can't transfer data. So that is one restriction on cross-border data transfer that is there. A second restriction on cross-border data transfers is that for significant data fiduciaries, the special class of data fiduciaries I just mentioned, the government gets to decide XYZ types of personal data as well as traffic data, or what we call metadata. And these types of data has to be stored and processed in India. Now, this is going to be a huge hindrance to international trade. There's a whole other conversation to be had how this works out at the WTO and with India's GATS obligations. But this could be a huge compliance cost for foreign companies. And this could also, a very key concern for us, is result in increased surveillance. Now, if you make sure that citizens' data is kept in India, India has a much easier channel to access said data. And this could lead to surveillance as well as break encryption. Now, we'll come to that more in detail when we deal with Rule 22. But next slide, please. The Data Protection Board. So now this is the new sort of governmental arm that has been set up under the Data Protection Act. And now, what the data protection rules tell us is how exactly they're going to appoint members to the Data Protection Board. So, what we have is something called a search cum selection committee, which is basically consisting of representatives from the executive, from the union government, as well as a couple of people that are also nominated by the executive. So, essentially, the search and selection committee, completely consisted of the executive, gets to decide people for the data protection board, naturally going to be dominated by the executive. So we have a lot of concerns on the actual independence of this authority and if it will actually be able to uphold citizens' privacy over state interests. There is a huge amount of executive overreach and misuse that exists. And it also needs to be noted that the powers that the Data Protection Board have are basically exalted adjudicatory powers. Mostly, what they do is they adjudicate on data breaches. Unlike other authorities like SEBI, RBI, FSSAI, they don't have powers to issue rules and regulations. They don't have powers to set standards. So it's pretty much a pretty toothless authority, which most likely will have minimal impact in furthering citizens' privacy. Can we have the next slide? Yes, so now we come to the last and arguably the most evil provision in the data protection rules, which is state access to personal data. This provision says that the government can ask data fiduciaries to share personal data in the interest of sovereignty, integrity, and security of the state. Now, this power is given to the government without any sort of safeguard. Right now, if you look at something like the Telecommunications Act or interception rules, there is a review process. You have checks and balances in place to make sure that the information that you ask for, the data that you're accessing, is for a legitimate need and is not just taken willy-nilly. But no safeguards have been given here. And the reasons for taking this data, integrity of the state, sovereignty, security, vague terms. The government can decide what it thinks is in the interest of sovereignty and take any sort of data from data fiduciaries. And more importantly, it also says that data fiduciaries, that is companies, can't disclose the fact that the government has asked them for this information if that is prejudicial to the interests of India. So not only are they being asked to give the information, they can't even tell us that, hey, we have given this information to the government. So it is an extremely authoritarian, surveillance-heavy provision that has a huge potential for misuse. This also is problematic. Now, assume you have encrypted platforms that, like, say, Signal is end-to-end encrypted. Now, if the government asks Signal to give information about messages, contents of messages, traffic data, this is all encrypted information. Now, will Signal be expected to break end-to-end encryption and then give information? These are all things that are not clarified and will remain to be seen. Can we move on to the next slide? Okay, so now we have a breakdown of the rules, and now we will move on to some analysis, broad concerns that we have. If I could first turn it to Gautam. Gautam, could you tell us what are your major issues with the new DPDP rules? Gautam, can you hear me? Yeah.
Yeah, just I was unable to unmute myself. Yeah, I think that the summary of it has been provided in some detail. I think broadly the issues with the rules track the issues with the act when it was enacted, which is something that a number of us and IFF pointed out, which is broad and vaguely worded provisions that leave a lot of scope to discretion on part of state agencies, specifically when dealing with something like personal data and the right to privacy. In legislation, you want to minimize the scope of discretion. You want to make it as precise and as clear as possible the circumstances under which personal data can be collected, processed, and used without consent. And both the Act and these rules then fail to do that in ways that have been explained above. I think one thing, the hope was when the Act came out, because the Act was vague, the hope was that the rules then would plug in some of that vagueness and the imprecision, but instead it's been the other way around. The rules are arguably either entrenched or increased the imprecision. A few examples of that, of course, one is the leeway to the state or its instrumentalities to process personal data in order to provide any subsidy, benefit, service, certificate, license, or permit that is provided or issued under law or policy or using public funds. Now, that is, of course, extremely broad in its terminology, and it is also not limited. So, for example, when the Aadhaar case was being argued, the court did allow, for instance, the use of Aadhaar, which is, of course, mandatory collection of data in a certain way, for the purposes of availing of welfare benefits. And now that, of course, was contested, but even if you take that as the baseline, a provision like this goes substantially beyond that. It isn't limited to the provision of welfare benefits, but the terms it uses are significantly broader. So in that way, and one thing that has been noticed across the board is that the state and the state's agencies, have a tendency of overcollection of data, right? And so therefore, when the law and the rules provide this discretion, then inevitably you will have an overcollection of data. The other thing was that the data protection law, the act, did not include the constitutional standard of proportionality in constraining the government's ability to collect data, and that has been replicated in the rules as well. So while there are references to data minimization and purpose limitation, ultimately the standard is proportionality. So for instance, one prong of proportionality is that if you can achieve the same goal without taking recourse to data collection or infringing right to privacy, then your obligation as the state is to take that less restrictive method. But there is no mention of that in the rules, which is another problem with that. Right? So I think like one broad bucket of problems falls within the terminology, which is broad and vague and which allows for excessive discretion in the collection of data. And the second broad bucket of issues arise with respect to the Data Protection Board itself. And again, this is something that is a problem with the original act, and which is then replicated in the rules and is, in fact, in a certain way concretized in the rules. The Data Protection Board, which is envisioned in the act and then concretized in the rules, is essentially a body that you find in multiple jurisdictions across the world. In fact, wherever you have a data protection law, you need to have a body that will then address citizen complaints, and that effectively provides the infrastructure for implementing data protection and its principles. In constitutional law, these are known as broadly fourth branch institutions. So this is the same broad set of institutions as, say, a Human Rights Commission or an Information Commission, other such commissions, which are not exactly legislature, executive, or judiciary, but belong to a fourth branch of the state, whose job it is to implement certain rights using infrastructure and using mechanisms. And for these bodies, often the complaints and the proceedings will often involve the state and the executive as a responding party. If you have an issue with, say, a data breach in a public institution, or if you have an issue with a public body excessively collecting your data and you want to complain, you go to the Data Protection Board. And that in turn makes it of vital importance for the board to have independence from the executive. So much like the Information Commission, bodies of that kind, there has to be some degree of separation between the board and the executive, because otherwise the board will be unable to discharge its obligations, specifically when the complaint is against the executive or a public institution. Here, the problem with the act was that there was no guarantee of the independence of the board. And now, if you look at the details, which is a search and selection committee, and the way that you appoint the members of the board and their tenure and so on, you find that there is near complete control of the executive over every aspect of the functioning of the board, from appointments to tenure to terms. Um, and that is a big problem, because that really hamstrings the ability that the board will then have to assess and adjudicate and investigate issues of data breaches, of complaints, and so on. And again, if you compare it to other jurisdictions, you will find that other jurisdictions ensure that DPAs or the authorities are given that independence, are given that arm's length separation from the state, so that can happen. So I think, yeah, for me, there are of course other issues. I think Vrinda will address them as well. But yeah, I think these are the two broad buckets or heads that I would say are of specific concern when we look at the rules. And like I said, I think it's important to understand that the rules are basically, the flaws with them replicate the flaws with the original act. Like it's hard to have rules which somehow are better than the original act. There were flaws with the design of the original act, which now you see, concretized and further taken forward in the rules themselves.
Thank you, Gautam. Lots of interesting points I would love to double click on. But before that, I'd like to ask Vrinda to come in and give her broad concerns with the Act and the rules.
Yeah, I mean, I think Gautam's already laid out the broader framework, so I don't want to sort of repeat that. And I think there's 2 points, right, just in terms of outlining. One, like we've said, there are problems with the Act, and that is replicated in the rules. Having said that, at the end of the day, I'm still glad the rules are out because we do need a data protection law. And I think we need a functioning law. So in some senses, I want the rules to come into force. Because however it is, either we litigate the challenges, the sections that are not, that we don't think are, legal, and some of the sections we'll have to see how they get implemented in practice. I think it is important to have a law that is functioning because right now we are all suffering from not having a law. The biggest issue also in terms of the implementation is really going to be how the Data Protection Board functions. And we have seen this with the IT rules is a great example. So the IT rules also had a grievance officer and the Cyber Appellate Tribunal would be the appellate authority. But in all the years when the IT Act was enacted, Rule 43A wasn't really used in terms of sensitive data protection rules. So a lot of it is also, it will be very important to have a data protection board that is functioning, which is why the concerns about independence that Gautam has highlighted are there. And in fact, one of the things that I find very interesting is just, for people who've been doing this now for so long, when the Justice Sri Krishna version of the rules came out, the first version, there were a lot of criticisms of that version as well. But now we almost look back at that version with some kind of, at least it had the words necessity, proportionality within the text, and it was not left to some arbitrary authority deciding, do we need to have a proportionality standard or not? Like, it's easy to say Puttaswamy is the law of the country and it has to be implemented. But I wish the rules had actually taken an opportunity to go further and put in those standards within the text very clearly. So that's just like the broader concern. I think you've already sort of mentioned Rule 22 in the rules. I don't want to, which to me is really problematic. So 2 points, right? One on Rule 22. If you see Rule 22, it actually derives itself from Section 36. It doesn't come from one of the exemption sections. And then, if you go back and look at Section 36, it's this very benignly worded provision which just says the central government may, for the purpose of this act, require the board and any data fiduciary or intermediary to furnish such information as it may call for. So in fact, when the act came, everybody was focused on the exemptions and those sections. And kind of Section 36, nobody really knew what to make out of it. But Rule 22 gives so much teeth to Section 36 and such unchecked powers that along with the exceptions, this to me becomes very problematic because you are then saying for any of these purposes of sovereignty, security, integrity of India, and we've seen enough case law to say you're just going to say this is required for national security purpose. Nobody is ever going to define what that national security purpose is. To call for information and then to not even let the individual know, I think it's really has the potential to be misused and the potential to create a mega surveillance state. We already, as citizens, have very limited rights when it comes, against illegal surveillance, whether it is mass use of surveillance mechanisms such as Pegasus, which we know, petitions are pending in the court, but even to get RTI information. So IFF itself, we've been litigating the fact of just tell us in how many cases did the central government authorize surveillance requests? Don't give us any particulars, just number. Under 69A of the IT Act, how many surveillance requests were issued in 1 year? And none of that information is given because national security. So when we look at how national security is going to be interpreted, Rule 22 actually can allow the government to get a lot more information which without telling me, and this without telling me becomes important because it is not like the police authorities currently do not have this power. Under what used to be Section 91 of the CRPC, the police has the power to call for information about individual users to, from intermediaries. So it is not that the government lacked this power to collect information about users. So what is the need to add another layer and another power where, because it is not going to be disclosed to me, so does this mean in a criminal case, if it is going to be used, how will that apply? And I think this interaction with criminal law is not something we've really thought about. How will the DPDA then affect criminal law? So that's kind of on Rule 22 and general surveillance concerns, and we can speak about that more. And the other point I also wanted to highlight is now we have to see how the RTI Act will also apply with Section 8 being being amended, and to really have an exemption where we say any personal information is going to be protected by privacy and hence that information will not be disclosed. I think it really can undermine the RTI Act and undermine the importance of getting information, because even judicial assets are personal information, right? But we believe that there is a public interest, and the Supreme Court believes there is a public interest in getting this information. So these are some of the specific concerns that I wanted to highlight, and then we can go into any further questions that you may have.
Thank you, Vrinda. So I think I'll just start with a question to Gautam. So you had sort of talked about Rule 5 and the exemption to subsidies, benefits, things like that offered by the state. Now, how would you look at this from the perspective of legitimate state interest under Puttaswamy? How do you sort of balance the state's imperative to make sure welfare benefits reach as many people as possible versus protecting privacy?
Yeah, I think so. To an extent, as far as the question of welfare benefits goes, was answered in the Aadhaar case when the court said that that Aadhaar can be made mandatory for the provision of welfare benefits. Obviously, something that some of us didn't agree with. We argued against it, but that's what the court said. Now, of course, part of the reason for the court holding so was the court also finding that the nature of the data collected by Aadhaar is minimal, and therefore, on an overall analysis, that test is made out, and so arguably a more intrusive, data collection would not justify, that even for welfare benefits. I mean, the basic point is that the legal standard is that of proportionality, which means that it's a four-pronged test. So you look at first the legitimate, of course, there has to be a law, which in this case it exists one, legitimate state interest, and you can argue that okay, the headings or the things mentioned in Rule 5, subsidy, benefit, service, certificate, license, permits, are all part of legitimate state interest and ensuring or the need of data for that. But the real teeth or bite of the test is in the third step, which is the necessity prong, according to which, like I said a little earlier, if you can achieve that goal, the state goal you need to achieve, without infringing that right, in this case, the right to privacy, or without the data collection, then you have an obligation as a state to do that. And the fourth step, which is that is the extent of data collection justified by the importance of the state goal. So you have to look at it on a case-by-case basis and see if that instance of data collection is justified by the nature of the goal, why you need the data, what you need it for, the extent to which you have to collect data, and so on. Now, if that test had been encoded in the law and in the rules, that would then be a different matter. Instead, it's not been, right? So there's this blanket exemption that data can be collected for the purposes of X, Y, Z, A, B, C, and that's where the problem is. The guardrails upon data collection that are provided by something like proportionality as a legal standard are missing from the rules.
Right. Now, I think I'll start with Vrinda, but I would like Gautam also to come in on this question. This is on the independence of the Data Protection Board. So I recently heard a government official say that the fact that the Data Protection Board is pretty toothless and it's not an independent regulatory authority like FSSAI or IRDAI is by design. They intended for it to be toothless to make sure that it doesn't over-regulate to make sure that there is space for innovation and businesses to flourish. Would you say that that legitimate interests of ease of doing business, of flourishing innovation, justifies the kind of lack of powers and independence that the Data Protection Board has? Vrinda, if you could go first.
I mean, absolutely not, right? Like, you don't have a law and then say, oh, the enforcement mechanism is going to be toothless because we want to do ease of business. You allow for ease of business and innovation in terms of how you structure the provisions and what are the obligations. If the concern was actually innovation, I think a big issue is data localization requirements that have now been introduced through significant data fiduciaries, which has been introduced through the rules, which I really don't think can actually even happen. But when the law has made a clear decision that we will not, and this is something that has been debated for years, and whether we want data localization or not, and when there was a decision that we don't want data localization, to actually introduce that through rules, I don't think you can really talk about the importance of innovation in some senses. And I think everybody will, even for businesses want certainty. It is not that you want somebody who's toothless. You want certainty in this is what the law is, this is how it's going to be applied. To have to say that, yes, we have made it toothless because we don't want to affect innovation, I think really undermines the purpose of having a law, because then you're also incentivizing bad behavior. You're saying that because it's going to be toothless, it's not going to, there's no incentive for companies to comply. And I think one of the things, I think Jairam Ramesh had put this in one of his dissent notes in one of the iterations, something to the effect that in a way the law is trying to be extra strict on private corporations and as liberal with government agencies, right? The government is the biggest data fiduciary of them all. And when you look at the exemptions that are applicable to the government, I think we needed better rules to apply to the government. So yeah, I kind of really disagree with that. And just another point I wanted to make on, when we were talking earlier, another issue, something which is interesting for me to consider is, you see the use of the word even due diligence, right? When we talk about parental consent and that, yes, all intermediaries must ensure due diligence. Seeing what has happened with the IT rules and how the phrase due diligence has now sort of expanded to mean so many things, and it's the basis of all these new IT rules 2021. I mean, it's also interesting to me how these phrases can be used by the government for expansion of power and to say that, yes, we don't want overly prescriptive regulation. So that's also just something I wanted to flag, sort of use of due diligence and how it's been interpreted in the IT rules standard.
So Gautam, same question, but I just like to add, picking off of what Vrinda was saying, she talked about data localization, and there is a perspective that you can say that requiring data localization is India's effort at making sure that we have data sovereignty. You can read it in with policy efforts to make sure data centers are being built in India. India's Make in India, India comes first sort of narrative that they would like to build. How would you see that policy imperative tying in with data localization as well as toothless data protection board for innovation?
Yeah, I think on that data localization bit, I think the answer, I mean, what you're saying is not through coercive legislation, right? So if you want to data sovereignty, you achieve that, like you said, by building data centers and by ensuring that it happens. Mandating data localization, for me is not how you achieve that. I think on your, and just to add one point to the issue of the independence of the data protection board. So I don't see how, I mean, so this conversation that, or this government individual who said that it's by design, I don't see how bringing the data protection board under the control of the executive is going to, even if you assume that the role of the board is to facilitate ease of doing business or innovation, which again, these are loaded words. What they mean is a matter of debate. So, but even if you take these words or these phrases as what the goal is, I don't see how bringing the board under the executive's control is going to achieve that. In fact, it would seem to me that's quite counterintuitive. The more independence you give the board, the more likely it is that then the board will not be, driven by government imperatives, right? Then the board will be driven by, the way the purpose and the goal of the act, and to fulfill that. So I don't see the link between like making the board toothless and fears of overregulation or stifling innovation. There's a big disconnect over there.
Right. I think another thing that I'd like to hear from both of you about is on parental consent. So now we have parental consent for children, and you have guardian consent for persons with disabilities. Now, from a rights-based framework, what does that mean for now? Essentially saying that children and persons with disabilities don't have right over their data anymore. Also considering that the definition of child is until the age of 18, and it is a blanket restriction on persons with disabilities as well. I think, Vrinda, do you want to go first?
Yeah, I mean, with the issue of persons with disability, you've already highlighted it. It's absolutely, I mean, it's just a disgrace, right? Like you're killing the autonomy, you're undermining. When you've had all these Supreme Court judgments which recognize the importance of autonomy and dignity of persons with disability, to club all of them as requiring parental consent, and to also club them in a provision with children, just as a matter of form, I think is not good form. And it's also completely unnecessary. So I think insofar as it applies to persons with disability, it is obviously extremely broadly worded. The issue with children sort of again goes back to the point that we've made, that the Act defines children as under 18. And so you are not having any gradation of a child who's 5, whose data is going to be used when you watch Cocomelon or some YouTube Peppa Pig or something, versus a child who's 16, who's accessing social media, as per the terms of Instagram, where you are allowed to be over 13 or 16, depending on where you are, to be able to access the services. So the fact that there's no gradation is a problem. And so this one-size-fits-all approach really doesn't work. It's also, I mean, verifiable parental consent, I think, will be tricky. Now, the rules don't actually give that much clarity, right? So the rules say that this consent has to happen before processing the child's data. So effectively, then they are talking about age gating in my mind, because they're saying it should be before processing. So if there's no self-declaration that is permitted, then how will it work? And this also goes back to when you talk about gradation. Is gradation, one is in terms of age, one is also in terms of the content that you are accessing. So access to a dating website should be regulated slightly differently from access to reading a newspaper. Now, if I'm reading Indian Express online, whether self-declaration should be sufficient, do you need parental data, parental authorization and verifiable parental consent, versus if you're using, say, social media, or if you're accessing, like I said, some dating website or, shops, that could sell alcohol or something, although that isn't really not a real issue in India. So I think these are the bigger concerns. Like, I don't think we are actually still, even after the rules, very clear on how verifiable parental consent will happen, and whether this is going to mean age gating, and will self-declaration suffice, or we need government data. Then the other point, or parental data. And then the other point you used in terms of centralization, right? Now, they specifically talk about the use of digital lockers, and so then the use of digi-lockers. Now, is this, instead of then simply just verifying that the parent or the guardian has an authority to give consent, are you actually going against the idea of data minimization by incentivizing collection of unnecessary data? And most people, we know, will just mindlessly give the data. So you're actually getting Aadhaar numbers, Aadhaar information, and none of this is really necessary in all cases. And so I think there is an issue about centralization and data minimization in the use of more and more data. And I think what it's really going to do is, it's the same thing with DigiYatra. Yes, it's voluntary, but when you have a two-tiered system where access to a service is much faster and much more convenient if you have this government data or this government app, then you're incentivizing people to really, it's not a free choice. It's not fair to say, yes, there are 2 lanes, but one lane is much faster, but you have to, it's voluntary. You can choose to experience inconvenience and go by the slower lane if you don't want to give your data to us. And so I wonder whether, again, this use of DigiLocker and, to centralize data is going to be an issue. So to me, actually, those are other concerns in terms of, DigiLocker being a concern for centralization and also being inadequate, and how they will age gate. And then the last point I want to make is also the lack of digital literacy in India. I mean, in many cases, the children are the internet first generation. It's not the parents. So actually asking parents to really going to be able to verify their data and to be able to upload it, how will this work? I mean, we are not thinking about customers like you or me. You have to think about the entire country. How will this work in a country where digital literacy is still so low, where there are shared devices still in a huge way? And where in many cases, it's the children who know how to access the data and not the parents.
Thanks, Vrinda. Gautam, would you also like to pitch in? But I would also love to hear what you have to say just on the ethicality of giving children's data, sort of making parents the custodian of that and making guardians the custodian of data belonging to persons with disabilities.
Yeah, I think it's pretty much all been covered, Vrinda, but there's nothing really more to add other than to note that yeah, I mean, there is a general sort of there is a sort of strain of paternalism that runs through Indian legislation in terms of depriving children of meaningful agency in any respect. So I think that yeah, that is continued by these rules. And of course, the disabilities bit is substantially worse. But yeah, I think the rest has all been covered. So I don't want to take up too much more time on that.
Thank you so much. I think we can now move on to questions. Also, next slide, Anjane. If everyone could drop their questions in the chat, we can take, I think, 2-3 odd questions. Get Vrinda and Gautam to come in. I see that there are a couple of questions here. So I will start with this question on from Kevin Thomas. Considering that the tech field has become more data centric with each passing year, how do you think this legislation would hold up in the long run, and what could the implications be? It seems like everything is leaning towards being data driven and leaves us data principles with significant concerns as to how it would affect us. Gautam, Vrinda, would any of you like to take this?
Could you repeat the question? Sorry, where is it? I was trying to find it.
It in the chat. But I
Could you
don't.
repeat the question? I don't seem to.
Shall I just post it into the chat?
You can just repeat the question. That's fine. Or Gautam, if you heard the question, then.
Okay, so it is considering that the tech field has become more data centric with each passing year, how do you think this legislation would hold up in the long run, and what could the implications be? It seems like everything is leaning towards being data driven and leaves us data principles with significant concern as to how it would affect us.
I mean, I think one, there's a reality that the law is always going to lag behind tech, and tech is going to be faster, and the law will have to play catch up. And I think that's why, to the extent that the intention behind the law to be more principles based is actually a good intention. I kind of think that's a good idea to not be overly prescriptive and then to have the flexibility to amend the rules. The concern is obviously our experience in the past leaves a bit to be desired. I think the only real, I mean, this is a philosophical question, I think that's really been asked. But to me, what has to be done as a data principle is actually to exercise your rights. And to say, yes, if it takes that one extra step, I mean, even when I access any websites online and, because of the EU, you have accept all cookies or only select necessary cookies. Even though it is that one extra step, you're like, okay, no, only these necessary cookies and not every cookie, right? So it is that one extra step. Speak out about it. And I think that is the best way for us to really make sure that privacy still remains a concern. And it's not just snubbed as this Luddite concern that's coming in the way of innovation.
Thanks, Vrinda. There is another question from Megha about children's data. So Megha asks, I wonder how this clause will apply to parents who create accounts for their children and often monetize posting content of children. In parallel jurisdictions, there are protections to the extent of ensuring that part of the funds the parents earn is used for children's benefit. So it doesn't grant the child the right to control their data. So anything on parents monetizing children's data? Gautam, Vrinda?
Do you want to take that, Gautam, or should I?
I mean, go ahead. And yeah, I don't have strong views on that. So.
I mean, yeah, I think the only thing, this is really more about like parent influencer content, etc. And I think it's more about the fact that we don't have any laws that recognize that children have any rights. Whereas obviously in the US, because of Hollywood, there's like a lot of rights that children have. So, I mean, under the current framework, definitely it's the parents that have all the rights insofar as the data is concerned and insofar as the accounts would be concerned, because they would have control over the account. So I think the answer to that is not a data protection answer. It's more actually having separate rules in terms of like influencer content and child influencer specifically.
Okay, I think we'll take just one last question. So this one from Aditya asks if the Data Protection Board should have representation from the judiciary.
Yeah, I think that there's generally like I think this perception that having judges involved like solve stuff. I think it's like what we've seen is the other way around, and nothing that I have seen like over the last 10 years leads me to believe that judges are any better protectors of either rights or for that matter like data involved rights than non-judges. I don't think that having a judicial member will really help on its own. It depends entirely on who you're getting on the board. You need to have people who both have expertise in data privacy and who have sensitivity to that to do these issues, which again then depends upon the entire appointments process, which as you've seen is under government control. So I think that's the issue. Like it's not just having a judicial member that's not going to solve the problem. You need to ensure that the way in which you select the members ensures that people who have both expertise and the right approach to this are the ones who are on the board, which of course as of now is not what the procedure is.
Thanks, Gautam. I think we can wrap this up. It is already 5. So thank you so much, Gautam and Vrinda. It was a pleasure having you here. And to everybody, just as a concluding note, please do consider supporting our organization so we can continue doing work like this. The QR code is given on the screen. Additionally, just to reiterate, the deadline for submitting comments is February 18th. And now to help you understand what sort of comments you can submit, Internet Freedom Foundation will be publishing our comments. We will be making it public in advance to February 18th, at least 2 weeks in advance. You should have our indicative comments that you can refer to and formulate your own thoughts. And please do as much as possible try to engage with the government. There are a lot of problematic rules, but they are still in the draft stage. With enough of our voices being heard, we can hopefully push forward a privacy fulfilling agenda and make sure the government listens. So please do make sure to comment as much as possible. Thank you so much to everyone for joining in.